welcome back to the Constitutional Clarion. This is the third part in a little series that I'm doing on the Commonwealth Government's Exposure Bill on the Communications Legislation Amendment Combating Misinformation and Disinformation Bill 2023. And I'm going to be looking here at some odd little things, some clauses up the end of the bill, which I describe as constitutional escape hatches, or in some cases they're known as historic shipwreck clauses. Now, what on earth does a shipwreck have to do with this? Well, I'll get to that shortly. But let's start with the first one, which deals with the implied freedom of political communication. As I said in the previous video, there are real risks that this bill would result in the censorship or the suppression of political communication, contrary to the requirements of the constitutionally implied freedom of political communication. So, what's the last resort in the bill for dealing with this? Well, it pops up in clause 60, and this is what it says. The provisions of this law and any rules made under it and any registered misinformation code and any misinformation standard, quote, have no effect to the extent, if any, that their operation would infringe any constitutional doctrine of implied freedom of political communication. So the effect of it is that we just say, no, here's our legislation and our codes, etc., and they say all these sorts of things, but by the way, if it's going to breach the Constitution, well, those provisions just don't apply. Now, the consequence of that is that you are shifting the burden from the government to make constitutionally valid legislation and moving it on to the person to whom the legislation applies to make the assessment as to whether or not they need to comply with it. Is it valid? Does the actual provision have any effect? Or is it a provision that has no effect at all because it would breach the implied freedom? Well, if you were the digital platform that was subject to these laws and codes, you could make that assessment yourself and say, well, actually, we don't think that provision of the code applies because it would breach the implied freedom of political communication, so we're not going to comply with it. And then you could be prosecuted and you could be subject to massive fines. And then you'd say, oh, well, the reason that we didn't comply with the law is that we say that the law doesn't exist because of the implied freedom of political communication. And then you end up in the High Court with a constitutional argument about it. Now you can see the problems with that, and that is you've got huge risk on the side of the person making this assessment because you've got the risk that you're going to be successfully prosecuted. And even if you then argue that no, this law is not, this provision is not effective, it does not apply because of clause 60, because it breaches the implied freedom of political communication, you've got the huge cost involved of running that constitutional case, which would probably get determined in the High Court, and the risk of costs if you happen to lose and make the wrong assessment. So if you're a digital platform and you're subject to this law, what are you going to do? You're not going to do any of that. And the government knows that. So effectively, the government can sort of make you comply with laws that the government itself says are not actually effective because they breach the Constitution, but they can put the burden on you to comply with it anyway, by doing this kind of weird switch by putting this little escape clause in there. I mean, I actually have a lot of problem with that because they're effectively transferring constitutional risk from those who make the legislation to those who then are subject to that legislation and are effectively making people comply with legislation even if that legislation is not valid. Is that an appropriate thing for the government to do? I really don't think so. All right, let's have a look at some other provisions in the bill that also do a similar thing. So this is where we get to the stuff about historic shipwrecks. Okay, so the context here is section 5131 of the Constitution, which says that if the Commonwealth compulsorily acquires your property, it has to give you just terms compensation. Now, sometimes property can be acquired under legislation where it wasn't really intended that the legislation have that effect. Okay, normally you know when property is acquired, if they take your land, okay, that's really clear. But what if they're acquiring some kind of right or some kind of interest, like, you know, intellectual property or something like that? Sometimes it's not quite clear. So it's understandable the government wants to put something in there to protect itself, to stop its legislation being struck down as invalid because they didn't have just terms compensation. So in an act back in 1976, which was called, ta-da, the Historic Shipwrecks Act, that was the first time they put a clause in there that said, right, well, if it is a compulsory acquisition of property, then we, the government, have an obligation to pay you just terms compensation. So you make sure you've got that escape clause in there that they get the just terms compensation rather than having the legislation struck down. Okay, seems reasonable. But what's interesting in terms of how that's been developed, and I should say, by the way, the High Court has said yes, it's upheld provisions of that kind. So what is interesting that's happened since then is that has then changed to a new clause, which is the clause that they put in here. And that's an equivalent clause to the one that deals with the implied freedom of political communication. So instead, what we've got in clause 61 is a clause that just simply denies effect to any provision in the statute or in the rules or in the standards or in the codes that give rise to a compulsory acquisition of the kind that would trigger section 5131 of the Constitution. So instead of saying you get your compensation, it just said, it didn't happen because the legislation just didn't apply. We have just disapplied that particular part of the legislation if it triggers this kind of a requirement. I'm concerned about this provision because it undermines certainty about the law, and that in itself undermines the rule of law. Because one of the most important aspects of the rule of law is that there needs to be certainty about it, and people need to know what law applies to them or does not. And this leaves that uncertain, in the same way as the provision about the implied freedom of political communication. Now, the final escape hatch we've got in here is clause 63, which seems to be seeking to escape from what's known as the Melbourne Corporation principle, which is one that deals with implications derived by the Constitution from the principle of federalism, so that the Commonwealth cannot effectively take over or assume all the powers of the states. And the very strange thing about this particular provision is that it does seem to go further than the Melbourne Corporation doctrine. It seems to apply to any powers that are exercised by the states or the territories. And if they're affected, then again it says that the legislation, the various codes, etc., do not apply. So all up, I'm not terribly thrilled by these constitutional escape hatch clauses. I can understand why the Commonwealth puts them in for safety's sake, but I don't think from a policy point of view it's actually very fair on the people who are affected by this kind of legislation. People need to know that the legislation is intended to apply to them. You can't just stick in little escape clauses and saying, oh, and by the way, if we made a mistake, then it just doesn't apply, so it never happened. And governments do need to have the burden on them to enact legislation that's constitutionally valid to begin with. They shouldn't be foisting the obligation of trying to figure this out onto the people to whom the legislation applies. Well, that's my view anyway. Thank you again for watching the Constitutional Clarion, and again, I hope you found this interesting, and I'll see you next time. Goodbye.